The big news of the day, of course, Derek Chauvin is in trial still. It's just getting started, really. And he's at day 19. And there were a little bit of interesting fireworks taking place this morning as it related to this other individual who thus far has been kind of under the radar. But it was the other guy who was in the car with George Floyd when this whole thing was unfolding back on May 25th of 2020. And this gentleman's name is Maurice Hall. And so his attorney was in court today. And, well, let's take a look at the trial board as is usual. This is what it looks like now. So we've got the usual suspects here. We had some activity today from Mr. Schleicher and Mr. Frank. And we also saw, of course, Mr. Nelson there. But we saw two new faces come into court. One is Morries Hall. You'll see him up here at the top right, and that is a screenshot. That's what he looked like. Now, my understanding is he's still in custody, and so they brought him civilian clothes. So he's suited up in a suit and tie. We've got an image of him here in a little bit, but we also have the public defender who was there in court today, and so she was arguing on behalf of Morries Hall, basically saying that we're invoking the Fifth Amendment, and he's not going to be testifying about anything. So we're going to explain what happened there. We also got to take a look at the other witnesses who were called in today. Remember that the government is still presenting their case in chief, so we're still sort of on this side of the board. And today they called in several other people. We have a crisis trainer who came into court. We have another crisis trainer or a use of force Minneapolis PD trainer, so maybe not necessarily crisis, but he's very familiar with use of force protocols. We also have this woman here. She is not a crisis trainer. She is a regular police officer who has some involvement with some of the medical roles. And we have this gentleman who is a use of force expert who actually came over from LAPD and testified about some use of force stuff. Yesterday, you may notice that we did not get to this woman who was an inspector and also somebody who testified a bit yesterday, and we just didn't talk anything about her. But I wanted to cover just a quick clip from her because it's sort of the theme that we saw today. So as I said at the start of the show, a lot of today was all about training, policies, and procedures. And the sort of the overall framework here is that the government wanted to say that this is very, very specifically prohibited. This is not allowed. What we saw Derek Chauvin do to George Floyd was way outside the bounds of possibility. And so they want to sort of parade in a bunch of their witnesses to come in and support that claim. So you're going to see this person, inspector, her name is Marie Blackwell. We're going to see another crisis trainer, another officer, all just kind of coming in and going, I have no idea what that was outrageous. Neck restraint. That's not even even in the realm of anything that's even feasibly possible under our policies and protocols. And so that they're really trying to be very clear on that. Then Eric Nelson comes back out and he tries to open that up a little bit. Well, but don't you have 30,000 pages of documents? And isn't it true that in certain situations when there are external factors that maybe they can hold that? And so, there are exceptions to all rules as is usual. And he's just sort of poking those, making sure that they're aware and exploiting those. And so I wanted to just start with Miss Blackwell from yesterday because it was part of the same theme that we saw roll in today. And so the way that we're going to structure this analysis today is we're going to hear from Miss Blackwell, then we're going to hear from Mr. Mercel, I think is his name, and they're both, and Mr. Yang, actually, they're all sort of making the same argument that I just outlined, that this is so outside the bounds, it's not even feasible, it's not even anything that would even be possible that would be allowed, part of the Minneapolis Police Department. And Mr. Nelson kind of rebuts a lot of the same claims all in the same cross-examination. So we're going to just take a couple clips from the trainers, from the government witnesses. Then we're just going to go through and look at Mr. Nelson, the defense lawyer, his response only to one witness, because he kind of takes care of all of the arguments with one cross-examination. So just to flesh out a little bit about where we're going today, that's what it looks like. So this is Marie Blackwell, and she is part of the Minneapolis Police Department. Let me tell you a little bit about her quickly. So she is the inspector of the 5th Precinct. She received her assignment on January 31st of this year. Previously, she was a commander. This is why she's testifying here. Previously, she was the commander of the training division, where she was promoted to that position back in 2019. She was promoted to a lieutenant position. And then when she became a lieutenant, that's when she was involved in the training and the academies. And she's actually known Derek Chauvin for about 20 years. And she was actually Chauvin was actually a field training officer at one point for a limited amount of time. And she goes through and she says, this is so important that we keep records of this, and we keep documentation about what all of these officers do, what training they received, so that if there's a problem, we can go back and say, oh yeah, Derek Chauvin took training on this particular day. And then they keep records about what the training entailed. And so they can sort of know more or less what the officers we're trained on. We do the same thing in law. We have to take what are called CLEs, continuing legal education, have to do a certain number of hours every year. And so we got to go in and sign the form and get our certificate, make sure we actually sit there, keep our notes. If the state bar wants to come and audit us, we got to provide it all. This is the training we got. This is proof I was there. And so a lot of industries have very similar things. This is nothing that is outside of the ordinary. But this woman is responsible, or was responsible back when she was the commander for the training division, for maintaining a lot of these logs and records. And so what the government did, the prosecution, they basically did that. They just ran through some of the records. You'll see here, it says continuing education credits. So they're calling them CECs. We call ours CLEs. Everybody calls them CEs, whatever. So it's just something that they're keeping records on. And you'll notice here, it says 2020 annual service training program, phase 1. We've got some dates on there, March 10th, 2020. Those dates are sort of, right before the stuff with Floyd happened. And so they're going through some of these records. We also see this other clip that was introduced, part of Exhibit 275, which says that on 11/30 of 2018, there was an 8-hour training session that it looks like Derek Chauvin attended. So we'll see that there. We got his badge number, agency, division, assignment. And what are they learning? Defensive tactics as taught in academy. They're also learning patrol ops as taught in academy. And so they spent a lot of the time today, or this was yesterday, but most of the theme today was all about this stuff: training and protocols and policies and procedures and use of force and excessive force and reasonableness and blah, blah, blah. So this is Ms. Blackwell yesterday, now sort of buttoning all of this up. All right, so we've gone through the documents, we've gone through the records, we've gone through all of your experience. We know you've been, all over the place here, been with the force for 20-something years. What's your conclusion? And so Steve Schleicher is now asking her what it is, and here she is communicating
I'd like to show you what's been received as exhibit.
Content warning 17. On this, we're about to see Floyd.
To ask you, officer, as you look at Exhibit 17, is this a trained technique that's by the Minneapolis Police Department when you were overseeing the training unit?
It is not.
And why not?
Well, use of force according to policy has to be, consistent with MPD training. And what we train are neck restraints, the conscious and unconscious neck restraint. So per policy, a neck restraint is compressing one or both sides of the neck using an arm or leg. But what we train is using one arm or two arm to do a neck restraint.
And how does this differ?
I don't know what kind of improvised position that is. So that's not what we train.
All right. Yeah. You can take that down. Thank you. I have no further questions.
All right, so it drops right there, right? And a pretty good way to drop the mic on the way out. I don't know what that is. I don't know what kind of improvised, whatever BS nonsense thing that is that Derek's doing, but we've never trained that. And so, again, we're not going to go into the cross-examination on this because Eric Nelson's going to sort of address all of these in one, and we have 3 clips from him. So for the sake of balance, we're going to move on. Now, that was yesterday. And again, the same theme was taking place today. But before we got into that, we had to talk about Maurice Hall, who was the passenger who was in the vehicle with George Floyd. And so this was him in court today. Does look like he is still in custody. He's in a nice suit and tie. Hair nice and combed, got some nice glasses on. But this, to me, back here looks like a jail facility. Certainly looks like he's still in custody. He just got suited up. And then he zoomed in. So the public defender is this woman, and she was invoking on his behalf. She was basically saying he's not going to come in and testify. And so it was kind of an interesting little exchange this morning. The judge is kind of like, well, I don't care. What does everybody say? He's invoking? Okay, great. So the public defender comes out, this woman, she comes out and says, Your Honor, FYI, representing Mr. Hall, we're invoking everything. We're not talking about anything because anything he says could be self-incrimination. And so Judge Cahill kind of looks at her and he's like, everything? Like literally everything? Because it seems like I should be able to call him in here and ask him questions. And if it doesn't specifically incriminate himself, then he should be able to answer that question. Like, for example, what if we called him into court and said, hey, what's your opinion on the weather on May 25th? How was the weather that day? And he goes, well, it was, kind of sunny, going to get gloomy real soon, but it was, it was nice, a little windy, didn't need a jacket. Is that incriminating material? Well, you can decide. This woman would have said, yeah, absolutely it is, in fact, because it put him in the proximity. So the judge was sort of trying to tease this out a little bit and say, well, what if we just asked him questions about what they were talking about in the car? Not about drugs, not about giving him a pill, not about selling drugs previously, nothing that would lead to evidence of criminality. What if they would just ask him general questions? And she said, no. Oh gosh, no, because that's going to put him in the car, right? That's going to put him in close proximity to this thing. And as far as she's concerned, he was not there. He wasn't even in the zip code or the area code or the state. In fact, she doesn't even know who this guy is. Who is this guy on the Zoom camera back there? I don't even know who he is. He's totally innocent. His whole thing's blown out of proportion, so he will not be testifying. She's doing a good defense attorney thing, right? No talking, no talking. And the judge tried to needle her a little bit and say, well, certainly, I mean, if we asked him about the weather, I mean, he didn't use that example, but something similar. If we asked him about the weather, he'd be able to come in and talk about that, right? She's like, no, not talking at all. Sorry. Because it's in close proximity. And so now that was her perspective. The judge then says, all right, Mr. Nelson, what's your take on this? If we called him, are you going to ask him questions that are incriminating? And he's like, yes, we're going to ask him everything. We're going to ask him about where he was, where he got the drugs, what he gave to Floyd, what he was talking about with Floyd, what he did after the fact. Oh, he also threw something apparently over a gate. We're going to ask him about that too. We're going to ask him about everything we can think of. Because they want to make him the culprit, right? They want to make him responsible for Floyd's death, for being a drug dealer, somebody giving him drugs that were overly laced with fentanyl or whatever the theory of their case will be when we hear that. Now, the judge obviously was like, okay, well, all that's going to be very incriminating, so we can't, we're not going to be able to ask those questions. Then he goes, all right, well, this is turning into a little bit of a circus. All right, government, what do you say, prosecutors? So they come back out. And now they say, well, judge, the only thing we want here is a fair trial. That's all. They want a fair trial. So they want just to make sure that this whole thing doesn't go off the rails. And if we bring this person in, Morries Hall, and he gets to invoke his right against self-incrimination, well, then we're going to be having to explain that to the jurors. The jurors are going to hear that we have this line of questioning going, and something, suddenly a question comes out, and the attorney has to object, and he has to invoke his right against self-incrimination. The jurors are going to be sitting there going, what the heck is going on here? They just put him on the stand and now he's not answering any questions. So there's going to be this big gap that exists that they're going to be missing. And, maybe they fill it in with a not guilty verdict. So the government does not want that. They want to make sure that this whole thing is just moving along as is. Judge ultimately is going to wait. He's going to ask Mr. Nelson to present a series of questions that he intends to ask of Maurice Hall, and then they're going to flesh that out. So very interesting morning from a procedural perspective. We'll see where it goes, but it is in the realm of possibility that he testifies or is at least put on the stand. We'll see where this goes. Now, we're going to fly through a couple witnesses. This was Mr. Yang. Mr. Yang was somebody who was part of the crisis training division, so sort of interfaces with civilians who also work in mental health and coordinates with them. Basically, if there's a situation like a George Floyd situation, apparently there's some division, somebody is thinking about how to respond to these things. Even though they didn't in that time, he's somebody who communicates about these issues. And so he was a training coordinator, and he testified today. Nothing, in my opinion, really stood out too much to me. He spent a lot of time walking us through this critical decision-making model. If you've been listening to the trial, we haven't been speaking much about this on this channel, but they are talking about it a lot. The reason why is because it's sort of, this is one of these things. It's a nice chart, and it gives us some guidance, and it gives us a process, and it gives us a framework, but it's so broad and generic that it's one of these models that you can kind of, I think, argue any which way you want to. It's sort of like a horoscope, right? Nobody reads a horoscope and says, that just does not fit me at all. Everybody goes, oh yeah, that kind of makes sense. I do get angry when people make me angry. That's weird. They get me. I'm such an Aries or whatever. People do that. And everything is like they can explain almost anything through these models. Same thing here. So you're going through here, okay, a threat risk assessment, authority to act. And so police are going to justify this one way or the other. They're going to say, well, based on my interpretation, I thought I could do this. Well, based on what we saw in the video, based on my interpretation, no, I didn't think we could do this. And so we're talking about the difference between subjective interpretations and objective interpretations. And it's a very difficult thing to sort of navigate in the law. So what they're doing is Mr. Yang gave us some guidance on this, walking us through how this works. And then everybody's going to come and sort of lay down their opinion using this model as an interpretive tool. So we have this next guy who is Johnny Mercel. So he oversees a big portion. He's involved in Minneapolis PD's use of force. And so he comes out and he's giving us some testimony today. We're going to start with, I believe this is the prosecutor. Let's make sure this is the prosecutor first. Then Mr. Nelson comes back out. And I think we have 3 clips from Nelson. He is sort of walking this back step by step. And it's a pretty nice job, I think, of what he does. Just progressively, with small iterations, working back the policy declarations that were made during the direct exam. So the government's asking questions. He's making all of these big, broad blanket sort of conclusions and statements about how things are. And then Nelson is slowly just sort of whittling that away as he goes forward. So let's take a look at this clip. This is the gentleman. This is Lieutenant Johnny Mercel. And this is what he looks like. And you can see he did not seem that interested to be there, in one man's opinion. You know, some people sort of have some energy and enthusiasm. He's just kind of pained on every question. It's like, ugh, yeah, I'll answer that too. Oh, you want me to answer that one too? I'm going to answer that too. So here he is. The prosecutor is examining him, and this is his conclusion before we jump into the cross-examination. And again, we're not going to spend a lot of time on this this theme, because we already have. We've seen a lot of this type of repetition. There's certain policies and procedures that exist. Claim is Chauvin didn't follow them, and this is sort of the third person now who is making the same argument. So we're going to kind of move through this one quickly, but here he is today.
Sir, is this an MPD trained neck restraint?
No, sir.
Has it ever been?
Not to my neck restraint, no, sir.
Never.
Is this a MPD authorized restraint technique?
Knee on the neck would be something that does happen in use of force that isn't unauthorized.
And under what circumstances would that be authorized? How long can you do that?
I don't know if there's a time frame. It would depend on the circumstance of the time.
Which would include what?
The type of resistance you're getting from the subject that you're putting the knee on.
And so if there was, say for example, the subject was under control and handcuffed, would this be authorized?
I would say no.
You can take that down, please.
Would not be authorized. And that's the end of that clip. So they kind of use him to get some pretty good unequivocal statements out, right? It's nope, never seen that. Definitely not a neck restraint. Essentially never been trained that way. But he does sort of couch that just a little bit. He says, well, there are certain situations when the neck might get involved in certain use of force situations. And the prosecutor says, oh, tell me, under what circumstances, good sir? And he returns and says, well, if the sort of the relative use of force justifies it, then it might be justified. But if it doesn't, then it's not justified. In this case, well, Floyd was in handcuffs on the ground with 3 people on his back. So what's your opinion on that? No, absolutely not justified. And as we heard, right, kind of unequivocal, just flat out, nope, never, not approved, never seen it, never done anything like that. Now, Nelson comes back out. And so let's flesh this out again, right? We saw the Miss Blackwell. We saw Mr. Yang use the different models. These are different police officers who are part of the same department, one after the other, coming out, laying out some pretty, I would say, clear, consistent blanket statements. So what Nelson needs to do is then sort of unravel that a little bit. And he starts in this next clip where he's talking about,
fair to say that,
where he's talking about whether or not it's okay to hold people until the scene is safe. And this is a big question that I think a lot of jurors will have in their minds is if Floyd is dying literally right under their knees, under their bodies, why did they not help? Why did they not move? Why did they not move his body around or start administering a CPR or anything to that effect? And the explanation largely, we knew this was going this direction anyways, was we needed to secure the scene. Police have different priorities. They've got priorities to collect evidence, right? They've got priorities to preserve life. They've got priorities to administer CPR and provide medical assistance. But they also have duties to themselves to get home at night. They also have duties to their colleagues. They also have duties to random civilians, and they don't want to let a scene spiral out of control. So the theory speculating here was that the defense would come out and say that they needed to secure the scene before they did anything positive for George Floyd. And this is where we're starting to see that come out. So now you're going to hear Nelson say, well, isn't there some training or some context or some circumstances where it would, in fact, be appropriate to hold somebody and not immediately administer aid? Here he is on that clip.
It's fair to say this is already in evidence, but in this bottom corner here, do you see a photo?
So that was the wrong clip.
Fair to say that the Minneapolis Police Department would train officers under certain circumstances to hold a person in a prone position until the scene is safe, correct?
There are circumstances where that is appropriate, yes.
And some of those circumstances could be the reaction of bystanders, correct?
That may be a factor, yes.
It could include where you are physically located in terms of a geographical area, correct?
Yes.
Right. Where you are in terms of other hazards that may present themselves to an officer or to the suspect, right?
Yes, sir.
Being in a busy street, in the middle of a busy street versus being in a park or a yard or something.
Yes, sir.
Right. So yes. You get a bunch of yeses from him. Yes. So there are certain circumstances where this might actually be appropriate. What circumstances? Oh, like if there's a crowd who's getting ornery around you, screaming at you, people yelling in your direction, saying, "I'm going to beat you. I'm going to do these things to you," which we've already heard from the government's own witnesses at the beginning of this trial when we were dealing with more of the civilian witnesses. So we know that was going on. We also have, you heard him say, how about geography? How about the specific location where you happen to be, like, I don't know, on the side of the road, in the middle of the road. They weren't even on the curb. They were sort of on the other side of the police vehicle because Floyd had come out the other end. And so he was almost in the middle of the road. And so you can see what he's doing. He's saying, how about all of these other factors? We just heard you say that no, not ever possible, not even, can't even imagine any circumstance. But there are certain factors that if you are an officer at the scene, is going to be Nelson's argument, maybe those lead you to a different conclusion. And if it's a different conclusion, that's not murder. That's a policy interpretation. We did something a little bit differently by the own guidelines that are enacted throughout Minneapolis. We were following the rules. Somebody died. You interpret the rules differently than I did. You weren't there. I was. That's reasonable doubt in the eyes of the jurors, I would think would be Nelson's argument. So here is another clip from Mr. Mercel, says that training, that there actually is some knee in the back and neck area. This is a clip where I think they're looking at a training module. So Mr. Nelson actually went through all of their documents. He asked Maria Blackwell previously about, I guess they got a search warrant to go into the Minneapolis Police Department and just get copies of all of their training documents. And so Nelson mentioned earlier yesterday that there was something like 30,000 documents that were in his possession. So presumably him and his team, they went through and they found this little clip that shows, well, officers in uniform doing training, and you notice that there's a knee on somebody's neck. So he's asking him about this now. We just heard never. It's not even, can't even identify what that is. Maria Blackwell said, never even seen that before, right? Don't know what kind of improvised little maneuver that was. And then here he is now saying, yeah, actually there's a picture of it in one of our manuals.
This is already in evidence, but in this bottom corner here, do you see a photograph of an individual demonstrating how to handcuff a person?
Yes, sir.
And that knee is across the neck of that individual, correct?
The knee is on his far shoulder.
Across the neck, the base of the neck.
The shin would be from his toes up to the knee. Yes, the shin is across the back of the neck.
So that's when we're talking about prone handcuffing. This is a specific kind of photograph that demonstrates the placement of a knee as it applies to prone handcuffing, correct?
Correct.
And ultimately, if that person were to be handcuffed and circumstances dictated, the officer would be permitted to continue to hold his knee in that same position. Agreed?
I would say yes. However, we've cautioned officers that be mindful of the neck area and to look for the shoulder for placement.
Perfect. We can take this.
Okay, so what he's doing here, what Nelson's trying to do is just say, yep, there are certain circumstances, and you may have watched that and you said, well, yeah, but that knee does look like it's on his shoulder. It doesn't look like it's on the neck, right? We're going to get there in a minute. But the point here is that you're seeing very similar maneuvering between bodies. What we saw in that image, not that far off from what we saw on the Floyd situation. And so it's close. And so if you're a juror, you're going, wait a minute, that's okay, but that's murder? So like 6 inches in one direction on the patella where the kneecap is, if that's just like half of a foot over one direction, that's murder, but this is an approved policy? What? That's kind of strange, because what if Chauvin now just didn't perform the maneuver correctly? Is that intentional murder? Is that gross negligence, or is that just kind of regular negligence? Is that a deprived mind, or is that just he just is an idiot and he doesn't know how to do a proper, restraint on somebody? That's not a murder charge, right? Is where this is going. But the difference here, at least from that visual, is, of course, in that image, that person wasn't in handcuffs. That person had his arm up, and so somebody was leveraging the arm. I used to do some mixed martial arts. I wrestled all 4 years in high school and then did MMA at a club here at ASU. And so I'm pretty familiar with how to maneuver the body around, and I love grappling. And so a lot of this looks familiar to me. So, you have different leverage points when you hold somebody's arm up, when their arms are behind their back and you've got your full weight of your body on their neck or even their back. And so you're sort of talking about different things, but the point is it's not outside the realm of possibility. And so thus far, what we've been hearing from the government is that, there's anything like closely related between the knee and the neck, like in that general vicinity, is a big no-no. But then Nelson just pops up, shows an image from their own training manuals, and it looks kind of similar to what we saw with George Floyd. And so this is just the sort of opening conversation. In this next clip, we're going to actually see that by this officer's own sort of acknowledgement that there is one way to interpret where, in fact, Derek Chauvin's knee was actually. Was it on the neck? Was it across the shoulder blades? Was the shin across the back of the neck with the knee, the patella, the kneecap on the shoulder blade, or more in the middle of the back? What? All right, let's take a listen here what Mr. Mercel has to say. Now, we got two clips. We got two clips from two different angles. And so what he's doing is Nelson actually pulled some still frames from the officer's body camera footage showing different angles. And you may have seen this. I think we talked about this yesterday, camera perception bias, and how the officer, the police chief himself, was even having a difficult time understanding where the knee was from that testimony that we had yesterday. And so this is another one to corroborate that. Here it is from Mr. Mercel.
I'm going to show you what has been introduced as Exhibit 56 already. Can you see that, sir?
A little aware of it. Yes, sir.
It appears to be the
Yes, sir.
appears to be the paramedic checking the carotid pulse of Mr. Floyd.
Yes, sir.
In your experience, this is already admitted as Exhibit 56. In your experience, would you be able to touch the carotid artery if the knee was placed on the carotid artery?
No, sir.
Okay, big point right there.
Can you just generally take a look at that?
Yes, sir.
Now, in terms of, do you recognize that this appears to be a still photograph taken from a body-worn camera of one of the involved officers?
That's what it appears to be, yes.
There's a timestamp on it that indicates May 25th, 2020 at 20:23:32.
Yes, sir.
And can you see two officers in this area here holding Mr. Floyd?
Yes, sir.
And clear this. Here, does that appear to be the placement of one officer's knee?
We're going to see it.
Yes, sir.
Does that appear to be across the shoulder blade to the base of the neck?
The shin appears to be across the shoulder blade. I don't know if I can tell you where the knee is.
So we'll just, I would offer 1045. Officer King.
All right, 1045 is received.
Permission to publish.
All right, here we go.
So what we're seeing here, again, this is at 8:23 and 32 seconds, correct?
Yes, sir.
And obviously this is taken from one of the body cameras. And here you can see down in that area, the leg placement of the officer, correct?
Yes, sir.
And based on your observation of this photograph, it appears that the shin is coming from the top of the shoulder across the shoulder blade, correct?
Yes, sir.
And it appears to be at an angle pointed in towards the squad car, correct?
Yes, sir.
All right. We can take this down, Your Honor.
All right. So it looks like the shin's going across the back, looks like it's going in towards the back of the vehicle, and he's going to show us another clip on this. And so you're starting to hear this guy go, yeah, it's kind of does look like it's across the back, kind of does look like it's across the shoulder. Maybe it's coming across, and they talked about his traps and things like that earlier on. And so this is sort of honing in on this. Where was it? Well, was it on the neck, or was it kind of coming across the back, over the shoulder, across the shoulder blade, back towards the police vehicle? And that's only the placement of the knee. You also heard him say earlier that there was the carotid artery that the medic who showed up right there was able to feel. And if they're able to feel it, well, that means they had access to it. So it wasn't being blocked by Chauvin's knee. So Chauvin's knee wasn't actually on that sort of really dangerous spot that exists in your neck. It was elsewhere, as evidenced by the fact that somebody showed up and put their fingers in the hand right there where they're claiming his knee was. So he's being very, very specific about this, moving the knee around like literally by inches, showing that in some circumstances, there's even pictures of this in the police manuals and their own documents. Then we have one more clip. So they're showing him a different camera, a different body camera angle that's a little bit higher up. So we get more of an angle looking down, and then you're going to hear him again sort of confirming what this looks like. And here is Mr. Mercel from the second angle.
So again, it's a little hard to see in this particular photograph, but if we look in this general area here, correct, you can see the placement of the knee, correct?
I can see the general area of the placement of the knee, yes.
And again, here we have what appears to be the shin coming over the top of Mr. Floyd's shoulder blade.
That's what it appears, sir.
And that would be angled in towards the squad car, correct?
Correct.
Yeah, so you can see that right here. Like, this is Chauvin's knee. If we're framing this out, that's the knee. And this is short. This is where the patella would be. And this looks like it's kind of right in the middle of Floyd's back. And the angle looks like it's going this direction back towards the car rather than this direction and down going over the side of his neck. And he's observing the same thing and looking at it and going, yeah, it's kind of hard to tell. I don't know. Kind of looks like it. Looks like the shin, knee. I'm not real sure where it's at. But the jury is now, this is an exhibit. So they're going to be able to look at this thing. Where was the knee? And is this okay? This is acceptable policy, but this is murder? They're going to have to ask that question, answer that question. It's a good question. Next up, we have Nicole Mckenzie. So she is a police officer. She's a medical support coordinator. She also administers the Narcan program. Narcan, of course, is that it's a drug that basically reduces the toxicity if somebody's having an opioid overdose and saves their lives. And so she got brought in today to testify. Didn't clip much from her. Let's get a quick update over from the Star Tribune. Afternoon testimony started with her. She is a medical support coordinator and the first aid educator of officers. She helped the prosecution make 2 points. Number one, that cardiopulmonary resuscitation, so CPR, can be started while waiting for paramedics to arrive, and that talking doesn't contradict someone's contention that they can't breathe, right? And so kind of, I would say some obvious points on that, but obviously, number one, they're always going to be saying, and we talked about this actually last night on Clubhouse, but there's a difference in priorities, right? There are going to be medical doctors and medical people like the firewoman who Genevieve Hansen came in, right? Her number one priority, save George Floyd, save his life, because she's a firefighter. She's trained to save people. That's what she does. Okay. Other people, if you're a tort lawyer, a civil lawyer, you might go there and say, this is a civil lawsuit. I'm watching a civil lawsuit happening right now. Right? Different people see what their expertise will show them. And so, the difference is between paramedics and police officers. So a paramedic or somebody who works in medicine may say, oh yeah, obviously number one priority would have been to flip Floyd over, start giving him CPR, save his life. For cops, unlike this woman who has a different perspective, they're saying, no, we're on the side of the road. Number one thing for us to do is to protect the scene, preserve our life. Then we'll get medical treatment later down the road. And this was backed up by the medical people who actually showed up on the scene, right? They didn't assess the situation and say, now's a good time for us to do CPR on the side of the road. We picked them up, picked up Floyd, went around the corner, hooked him up to the CPR machine, started doing the chest compressions, and because we knew ourselves that it wasn't safe there. So her testimony, I think is largely inconsequential for those reasons. I don't think it really fits with the other people's testimony. And she also talks about "I can't breathe" as being contradictory. So, there was one statement that said that Chauvin said specifically, or somebody said, if you're talking, you can breathe. And so she came out to sort of rebut that. So, it's fine testimony. I just didn't think it was particularly consequential, so we're not going to spend too much time on it. Let's just finish this article. Mckenzie acknowledged under questioning from Nelson that police officers should ensure that the scene is safe before rendering aid. This is a theme that the defense attorney has visited numerous times since his opening statement last week. He also asked whether agonal breathing or involuntary gasps, sometimes made by people under cardiac arrest, could be confused with regular breathing, and she confirmed that as well. She also agreed that the chaotic scenes can contribute to a first responder's ability to provide aid. So, a lot of sort of opinion testimony going back and forth. Nothing I think was particularly moving the needle one way or the other, so we'll move past her. Then the last person of the day is Jody Steiger, who is a Los Angeles Police Department use of force expert. They have something like 9,000 officers over there, so presumably this guy deals with a lot of that. Well, they are the LAPD after all. So he is probably pretty well versed in some of this stuff, and they brought him in as an expert witness today. So the government flew him out. He kind of joked in court, "Hey, I'm on vacation," right? This is not his normal day job. He's out there testifying as an expert witness. And so he was in court today. This is what this gentleman looks like. And I got to be honest, I would say less impressed with his testimony than I would have otherwise expected. He was kind of meandering a little bit, kind of felt a little nervous to me. And I'm not real sure how effective it was because he didn't seem, as he was speaking, like he had a real command of the information in front of him. You can be the judge for yourself. Maybe I am wrong on that, but for somebody with, I think, as much gravitas as they would expect from him, he sounded a little bit unsure of himself, in my opinion. But here he is. He is talking about his final conclusion about use of force. And actually, he's not done testifying. So he's going to be called back in tomorrow morning. And so we're going to hear more from him tomorrow. And I think Eric Nelson will still be up for cross-examination, but I'm not even sure that the government has finished their direct exam. So here is Prosecutor Schleicher, who is asking questions now of Steiger.
And were you able to make any kind of assessment in this case as to whether or not Mr. Floyd was offering resistance or trying to evade law enforcement officers?
Yes.
And what was your assessment?
Initially, when Mr. Floyd was being placed in the backseat of the vehicle, he was actively resisting the officers. So at that point, the officers were justified in utilizing force to try to have him comply with their commands and to seat him in the backseat of the vehicle. However, once he was placed in the prone position on the ground, he slowly ceased his resistance. And at that point, the officers, ex-officers, I should say, they should have slowed down or stopped their force as well.
Right, so you see what I'm kind of a lot of, well, they kind of should have stopped their force as well. It's like, all right, that's all well and good. So that's his testimony. He'll be back tomorrow. I think that the government's going to finish up with their direct exam, and then we will see the defense attorney come back out, and then we'll see a rehabilitation. So we'll see more from him, and I'm sure he'll be ready to rock and roll tomorrow. So let's take a look at some questions over from locals.com. I am queuing up the questions as we speak right now, in fact. And so let's take a look at LT13. So these are over from locals.com. Says, LT13 says, why does it sound like Mr. Hall is only going to maybe answer a few questions and not have to go up and plead the fifth in front of the jury? So I'm not sure I interpreted it that way. I think that the judge was asking Nelson for a series of questions that he would be proposing to ask Mr. Hall. And depending on the nature of those questions, some may be allowed and some may not be allowed in front of the jury. So that if the answer is yes, that you can ask, this series of questions because it doesn't incriminate him. It gives us valuable, relevant information in the trial, but it doesn't incriminate Mr. Hall. They'll allow those questions in front of the jury is how I interpreted it, because the jury needs to hear it, right? This is a trial. It's for them. They're the fact finders. So they need to hear from Mr. Hall. If he doesn't, if he testifies in outside of the presence of the jury, well, what the hell good is that? Doesn't do anybody any good. So we'll see. I think the judge is going to try to rule on that tomorrow. We have Deep State says, what is the likelihood of being called in to testify for witnesses on the witness list? Are certain types of witnesses, medical, use of force, more likely to be called in before the end of the trial in totality? What percentages of witnesses on a list usually get called? It's a really good question, Deep State, and it's really hard to answer here just because this trial is so unusual. Most trials are not like this. Most trials, the likelihood of your witness showing up is very high, like very high, right? Because most of the time when we have trials, it's just like 5 witnesses. If it's a DUI case, usually it's 5, maybe 4, sometimes 3. They're all showing up, no question about that. But this is a much bigger show, right? And typically defendants or witnesses against defendants will show up. That's the general rule, because you need them all. In this conversation, we're already seeing some cumulative evidence, right? We're seeing some people come out, even today, testifying about some of the same themes that are almost even a little bit duplicative. Yes, you have policies. Yes, we know the police department's official position on this story is that Chauvin was in violation of their policies, and you have nothing even remotely resembling that. Got it. That's your position. We got it. We don't need to hear about it from 50 other officers. And so anybody else who's already on that list that is close to being made to make that point, they're not going to get called, I would guess. But they might be on a hot standby for now until this part of the trial is over. And so, you kind of have your witnesses and you know what you need them to do. Sort of like if you ever play a card game or that Uno game. Remember Uno, right? And you get the cards, you throw the cards down and whatever that card was and you go, yeah. And you win the game and you reverse the order and all the people with the green cards get penalized or whatever. I forget how to play it. But that's the point, right? You know what your witness is, you know who they are, you know where they come from, and you know how to use them and when to play them. And so right now, I think I heard anecdotally that there were 300 to 500 witnesses in this case. So obviously we're not going to get to all of them. And so it's just sort of the prosecutor's tactical determination about who to call and when to call them. So this is a unique case, so it's hard to draw any generalities from this case. Deep State also says, to the extent that Hall made inculpatory statements to police or investigators already, can those still be admitted despite the Fifth Amendment invocation now? It seems highly relevant to Mr. Chauvin's defense if Hall already indicated to the police that Floyd took a handful of pills when police showed up to the scene. No, so those things would be hearsay, right? Those are out of court statements that would be made to prove the truth of the matter that is being asserted. So in this case, what we have are allegations or the question is, why do you want the witness to come into court and what purpose are they testifying for? You have to ask yourself that question. So Chauvin, I think both people subpoenaed Morries Hall now. Chauvin and his side, they want him in to come in and talk about all that, right? Gave the drugs to Floyd. Floyd's responsible. I was responsible for giving the drugs over to him. And that would necessarily extrapolate to the cause of death, which is a critical issue in this trial. And so, yes, that statement would lead towards giving the jury information about whether to assess what killed Floyd, which is the main point of this trial. So that just statement that's floating out there that Hall made to the police, it's considered hearsay, and I don't think the judge would allow that in, which is why the defense wants to get him in so that they can ask him about it, so that he can be cross-examined now so they can get around some of the hearsay rules. News Now Wyoming says, any guesses on how the judge will rule on Mr. Hall? Would him admitting he was even present in the car be self-incriminating? So I don't think so, right? I don't think that mere presence. So look, it depends. It depends on what angle you take. So generally speaking, I think that if you're a reasonable person, just the mere presence of existing alone does not incriminate you. If you put on the defense attorney hat, yes, it absolutely incriminates you, right? Just the fact that he was in the car. I would never tell my client, well, we're just going to say that you were in the car. How about that? No. You weren't near the bank. You weren't in the getaway car. You don't even know what a green dollar bill looks like. You had nothing to do with anything about that bank. Wells Fargo, what? Bank of what? Never even heard of it, right? You're not even anywhere near it. And so if you put the defense attorney hat on, that's what that looks like. But from a judge's perspective, is that really enough to incriminate him? No. So we got to think sort of from the judge's perspective. And honestly, I think this judge, he might allow some questions to come in because he is being selective about allowing some other questions to come in as it related to Floyd's 2019 prior. So the judge is being very, very granular with stuff. He's not just sort of making blanket exclusions or admissions. He's saying, well, what questions are you going to ask? Those are good. Those are not good. So those can come in. Those can't. So we'll see. I think that the judge might actually be inclined to let him come in and testify. Geek Dumb says, why will the prosecution not give him immunity if they are so sure Chauvin killed Fentanyl Floyd? So, they're not sure is the question. That's the answer. They're not so sure about this. And so they don't want to give him immunity when he's going to hurt their case. I think that's it. I think that's about as simple as it gets. We got Spoiler says Hall's attorney mentioned that he was not being offered immunity. Who has the ability to give the immunity? The prosecution does because they are the ones who charge crimes. Hall's testimony obviously is more likely to help the defense. Is the state the only side that can offer this? Yeah. So yes. Yeah. I mean, the judge can't compel the government to give him immunity. They got a pretty nice card on this one, don't they? Not bad. We have Justice First says, Robert, have you heard of conditioned compensatory response? And do you think Chauvin's defense might bring it up? If Mr. Floyd ingested drugs outside the normal setting, time and place, even the same type and quantity, he could have been more sensitive, even to the point of fatality risk, because his body would not have had the chance to mount its typical compensatory physiological response to blunt the effects. It's a great question, Justice First, and welcome, by the way. I just saw you signed up. Welcome to the community. We're glad you're here, and way to start off with a great question. So this is something that kind of came up. It's closely related in trial today, but they were talking about this specifically with Mr. Mercel, the guy that we played several clips from today. And the conversation was really about, are there other factors that may make it more difficult to deal with somebody who is in a situation like Floyd was? Namely, will they black out? Will they lose consciousness, and how quickly? Are there different factors that might impact how that process goes? And he said, yeah. If you have your adrenaline flowing through you, your blood's pumping, you're not getting enough oxygen, and so you start to hyperventilate, and you'll pass out just from hyperventilating, essentially. So if your adrenaline's flowing, like, I don't know, if you're being arrested by cops and you're having a panic attack, yeah, that's going to get your adrenaline flowing. Heart's going to be beating faster, and you're not going to be able to maintain consciousness. What else? Well, drugs, right? What if you have drugs in your body? Your body then has some sort of a response, now combined with the adrenaline, now combined with, COVID remnants. Now you've got the physical response that you have by being sort of, in an altercation with 4 different officers. All of these things compound on one another, and they got to be accounted for. And maybe it's that domino effect, that cascade of consequences that resulted in death and not the knee. So Nelson was really trying to extract that today. Good question, and good to see you, Justice. We got Joe Snow says, can you just come right out and take a position on Chauvin? I'm super torn in this case. No, I can't. Sorry. But we'll see where this thing goes. Look, here's the thing. I'm really trying not to politicize this case at all. And I really don't want to, because I really don't. I really want, more than anything, a fair trial. More than anything. And I want to do my part to sort of be even keeled on this thing. And I don't want people to watch going, oh, he's being too biased. I know that's going to happen anyways, but I'm trying to make a very level-headed, let's try to give equal time. I'm not claiming to be unbiased. Okay. I'm a defense lawyer. This case is a little bit unique because the defendant is a cop. Well, I'm not a huge fan of, generally speaking. Right. So it's a complicated case for me. I have a little bit of internal turmoil, contradictory tension, but we'll sort through it. The point is, we want to make sure that we have a fair trial. We learn a little bit about the justice system. We are able to I think, argue and interpret it from both sides, and we'll just let the system play out. Good question, though, Joe. We have another one from Sliding Edge. It says, does it matter that the witness said police, then corrected by saying former police? Wasn't there a directive to limit use of words like officer and victim? Just wondering. From Sliding Edge. There was an agreement about that. They did talk about, I think, using first I think using formal names, right? Mr. Chauvin, Mr. Floyd, that's what they were talking about. And that's the judge's general rule. But if nobody's calling it out, so whoever, I don't remember who said that, if it's the prosecution asking that of a witness and the defense says objection, whatever, they're using improper names, the judge might say, okay, sustained, but you need to go and use, proper names. Judge might technically rule in their favor on that, but that might look kind of petty to the jurors. So those types of maneuvers are just kind of tactical. You got to pick your battles. There's some things you want to fight and die on that hill. There's other things you just kind of let go. So next up, last one on this segment, we got Jason Segal says, could Chauvin's hand in pocket indicate he might be applying more downward force with his arm? Could Chauvin's hand in pocket indicate he might be applying more downward force with his arm? I'm not so sure that I could see that. I mean, versus I would say like bracing himself on anything to distribute that weight more evenly. We certainly didn't see that. And if you keep your weight sort of closer to your center of gravity, it's like if you want to like think about the alternative. Like think about if you're Derek Chauvin and you want to kill somebody with your knee. Maybe some people think he wanted to do that he set out to do that. I don't know. But let's say you wanted to do that, right? How would you maneuver your body in order to maximize the amount of pressure that you're squeezing into your kneecap onto somebody's one point? You want a focal point. And so how do you do that? Well, you kind of center your gravity a little bit. And you make sure that you just kind of adjust your center of weight over, a vertical axis. So it's all going right down on the back of the pressure of your knee. So you could argue that, hands in pocket, not leaning other directions may have contributed to more pressure. But I'm not real sure how consequential that would be. Is it going to be, 10 pounds of pressure versus 100 pounds of pressure, or 10 versus 11? I don't know. So very good questions over from locals.com. If you want to support the show, that's the place to do it. It's at watchingthewatchers.locals.com. Great questions today. Thank you so much for those.